distinguished speakers, ladies and gentlemen. I'm sure good morning. Yeah, I'm honored to be your MC once again for today and to lead you through the program. And yeah, that's just one little explanation. Last panel discussion will be on Thai, and we will have a translator, of course, translating for you. You have this translating device. You just turn it on here. This device here. You just turn it on. Just turn it on here, and you go on channel 2 for English. So just this to keep in mind for afterwards. So and then then just open this discussion right away. First panel with Professor Sen from South for the National University of Singapore, Dr. Fozi, and our discussant is Professor Haru. So yeah, please.
Thank you so much. Good morning, ladies and gentlemen, distinguished guests, participants, and also the scholars. It's really a great pleasure for me to chair the panel or the discussion at this moment, because we have very distinguished scholars in this issue, and I do hope that we can enjoy maybe we have a very good and entertaining discussion yesterday, and also maybe some of you went to cruise dinner, but we will still have one more day to discuss and also to explore this issue, which is quite interesting. And so our topic today will be the state and religion, the struggle for hegemony in defining the right formula. And our speakers, there are two speakers in front of you. The first one is Professor Ronald Joy Sen from the Institute of Asian Studies, National Institute of Singapore in Singapore. And this topic will be situating the Indian scholarism, reading the Indian Constitution and the Constituent Assembly debates. The second speakers will be the Professor Fozi Navid Ambifar. Am I correct? Pronounce your name? He's from the Middle East Institute, also from the University of Singapore in Singapore. His topic will be presidential election as crisis management, challenges of representation, knowledge, and power in the Islamic Republic of Iran. So, Professor Joy will talk first, and then followed by Professor Navid. After that, we will have, I will give any comments. Then we will have a free session for question and answers. Please let me read the CV of Professor Joy, Professor Sen. Dr. Ronald Joy Sen has worked for over a decade in leading Indian newspapers. He was last with the Times of India, New Delhi, where he was a senior assistant editor on the editorial page. Dr. Sen holds a PhD in political science from the University of Chicago. He has an MA in international studies from the University of South Carolina and a BA in history from Presidency College, Kolkata, India. He has been a visiting fellow at the National Endowment for Democracy at Washington, D.C., and the East-West Center, Washington, and a fellow of the International Olympic Museum, Lausanne, Switzerland. Dr. Sen is the author of Articles of Faith, Religion, Scholarism, and the Indian Supreme Court, which was published by Oxford University Press 2010. He has contributed to edited volumes and has published in several leading journals, including Pacific, Court, and Society. He writes regularly for newspaper, affairs, South Asia, Journal of South Asian Studies, Journal of Democracy, India Reviews, and so on and so forth. So for Professor Joy, Ronald Joy Sen, the floor is yours.
Thank you, Heru, for the kind introduction. I should also mention to have a joint affiliation with Asia Research Institute. I just want to acknowledge them because it's a joint appointment. I'm deviating slightly from what I was originally intending to focus on, which was the Constituent Assembly debates in India, which I thought might be a little too narrow for this audience, and in the spirit of this conference, what I'll do is I'll focus on a little bit on the Indian Constitution and the Constituent Assembly, but also try and provide a general overview of Indian secularism. And I'll try and stick to 30 minutes because I think we've already started a little late, partly due to the technical glitches, perils of PowerPoint. Yeah, here it is. One of the things to note first off is that Indian secularism is quite different from other secular models. For instance, France, where, as we know, there's a harder division between state and religion, but as we saw in some of the earlier papers, maybe it's not so hard as some people think it might be. And then the other European models where some countries, one religion is given an official religion status, or at least gets a privileged status, as we also saw in a couple of the presentations last time. The Indian model, while the constitution was being framed, borrowed quite liberally from the American one, where there is of course a wall of separation, but which has been in effect very, very difficult to define. In terms of some of the classic theories of secularism, India's secular state has been seen to have as one author who sort of wrote a pioneering study on India. Norman D. Smith came out some time ago, India as a secular state. He called these the constitutional anomalies, and I'll come back to that at a later point. That study also predicted, interestingly, 20 years later, that was, I guess, if the book was written in the 60s, and by the 80s, the author thought that many of India's constitutional anomalies regarding the state would have disappeared. And as we shall also see, these really haven't. And we can discuss why this hasn't. So the Constituent Assembly, for those of you who are not aware, sat between 46 and 49. So India becomes independent in 47. The Constituent Assembly is actually formed even before India becomes independent. One thing to note is that the assembly was not elected by adult suffrage, which the Congress party led by Nehru, Gandhi and the others had demanded, but was constituted on the basis of an election held while the British were still there in 1945, which was on a fairly restrictive franchise based on income, property. So it was only a fraction of the Indian population which actually elected the 30%. Another thing to note is that, which was not unusual, the Congress party, really the leading party of Indian independence, dominated the assembly in terms of numbers. The Muslim League, which also had substantial numbers by then in the 45 elections, the Muslim League led by M.A. Jinnah, the founder of Pakistan, had also done well in the Muslim-dominated constituencies in these elections, but the Muslim League boycotted the assembly proceedings, which is another very important thing to note. But after partition, because the Constituent Assembly straddled the partition years, because it started in 46 and then completes its proceedings in 49. So a bulk of the Muslim League leaders migrated to Pakistan. It was somewhat obvious because Pakistan was their demand, but some of them did stay back. It's not that all the Muslim League leaders went stock and barrel to Pakistan. So there was a reasonable Muslim presence in the assembly. Another very important thing to note is, even though the Congress party dominated the Constituent Assembly, it made an effort to include other notable both lawyers and leaders who weren't of the Congress tribe in the Constituent Assembly. And one particular person to note is Dr. B.R. Ambedkar, who is often regarded as the father of the Indian Constitution. India has a lot of fathers. Mahatma Gandhi is the father of the Indian nation, and Ambedkar is seen as the father of the Constitution. But he was really the chairman of the drafting committee, so he had a very critical role. He was a Dalit leader. Dalit is the term that now we use for the former untouchables in the Indian caste hierarchy. And yet another thing to note is Mahatma Gandhi was not part of the Constituent Assembly because he actually never stood for elections, even though he was critical leader of the Congress as well as, of course, the Indian national movement. He was, while the Constituent Assembly was debating, he was trying to maintain peace and harmony in the partition area. So he was very much removed from the Constituent Assembly deliberations, and in fact, he had some serious differences in the way the Indian state was and his various provisions formulated. But that's a topic probably. And I just have a visual. This is Nehru giving his very famous Freedom at Midnight speech at the Central Assembly Hall, which is still there. It is considered sort of one of the classics of oratory, where he talks about India's tryst with destiny at midnight. Quite a heartwarming and soul-stirring kind of speech. So the Constituent Assembly debates, there were roughly 300 odd Constituent Assembly members from what was British rule India. It was a bit complicated because there were parts of India which were also known as the princely states. And so they also had their representatives. They were not directly under British rule. In fact, there were almost 550 odd princely states, ranging from very small, from few acres of land to some which were the size of a European nation. So there was a lot of diversity there, which is, of course, the case. On secularism and religion in particular, there were a range of voices in the Constituent Assembly, as was to be expected, even though it was, as I said, dominated by the Congress. So there were some members who of the socialist bent, and there were, of course, some communists, but although the major Communist Party did boycott the proceedings, but there were a lot of Constituent Assembly members, the socialist bent of mind, including Nehru himself. He would often be described as a Fabian socialist. And some of them wanted the Indian Republic to be constituted into what they called a secular cooperative commonwealth. There were others, of course, with a much more religious bent of mind. And you must understand the Congress was a bit of a catch-all umbrella kind of organization, which had some, of Nehru's bent of mind, very socialist. There were others sort of in the middle of the road, and there were others who were very religiously minded. And so there were some of those members who, in fact, wanted the Indian Constitution, the preamble, to begin with the phrase "in the name of God." But in the end, what the compromise that was worked out was very much the Nehruvian position. And Nehru had written considerably on the role of religion, because he was a prolific writer, especially when he was in jail. Both Nehru and Gandhi actually ended up writing a lot. So one of Nehru's classics, Discovery of India, was actually written in jail. And one of the things he had said, and I quote him, is a secular state does not mean an irreligious state. It only means that you respect and honor all religions, giving them freedom of function. So in the end, the constitutional provisions were close to this sort of Nehruvian formulation, and it's a position that oscillates, and this is this is a Sanskrit phrase called Sarva Dharma Samava, which is roughly translated into goodwill towards all religion, and Dharma Nirpekshata, religious neutrality. Dharma is, again, loosely the word used for religion, and there was someone mentioned, I think Yuan, in several African nations there is actually no word for religion. In India, dharma is used for religion, but it can also have other connotations like law, justice. So that's something to note, that religion often across cultures, there is not a word that often has a close fit with religion, as well as the term secularism, which as in Indian context really doesn't have an exact equivalent. So these are the two phrases that have been used, and in some ways it's sort of similar, I think, to the Indonesian notion of, I think, Pancasila, where or the original conception when the Indonesian constitution was, I think, formulated of treating all religions separately. I think that has maybe changed over the years, or might be wrong. It was only in 1976, several decades later, that the word secular is actually incorporated into the Indian Constitution. And this is done during a very an odd phase. Between 1975 to 1977, India was under what was known as emergency under Prime Minister Indira Gandhi. That was the only 2 years when actually India sort of deviated from the path of democracy, election, even though this was an elected government in power. But Indira Gandhi suspended under an emergency provision in the Indian Constitution, several rights, civil liberties, right to freedom of speech, imposed a lot of censorship. And this was the time, under a particularly notable amendment, at least in the Indian context, known as the 42nd Amendment, the word secular, as well as interestingly, the word socialist was included in the preamble of the Constitution. And this was done actually without too much debate, because this was the time when the emergency was on. Here I just have a cartoon showing the process of constitution making, and this particular cartoon actually caused a bit of a controversy in recent times. This is Ambedkar is the one sitting on the constitution, which is a snail, and Nehru is trying to sort of whip the process into, because it's seen as going to as a very slow process, and Nehru was somewhat impatient of this whole process. So religion was just one of the issues that occupied the Constituent Assembly. It was the language issue, the federal structure. There were several other critical issues that occupied the Constituent Assembly, and that's why it took 3 years, but in the end it delivered the document. Now, quickly to move on to the freedom of religion clauses. Two very important ones. I don't want to sort of go over them today. Article 25 basically is the freedom of conscience clause, right, freely to profess, practice and propagate religion. And yesterday we had the professor from NUS, Professor Nitya, and she did mention that Singapore actually borrowed the idea to freely propagate religion from the Indian Constitution. But we should also note that the clause 2 does not restrict the state from making any law that can restrict economic, financial, political, or other secular activity, and this is interesting, which may be associated with religious practice. And the other thing was throwing open Hindu religious institutions to all classes of Hindus. And this, you must remember, is directly targeted at the caste system, whereby a lot of the Hindu places of worship were not open to the lower castes and the untouchables. And there was a long movement against this, and Ambedkar was one of the primary leaders during the national movement. And this element is important to note because the Indian Constitution is really in some ways also a social reform document. So there are all sorts of clauses worked in to reform and even to wipe out practices that were seen as regressive in the caste system. Article 26 is the other one. 25 and 26 are really the two primary ones, and that is, relates to the rights of religious denominations and groups to the various rights listed. I don't want to read them. There are a few others again. It's up on the screen, so I'm not going into detail. 27 is that the unweighted taxation on the sake of religion. 28, Article 28 relates to religious education in educational institutions. And then there are Articles 29 and 30, which relate to minority rights, the equality clauses. Which gives one of the important things to note is that minority institutions can establish educational institutions, and interestingly, the state there is allowed to give them funds, and some actually the more famous institutions in India. There's one very elite institution called St. Stephen's College in Delhi, is a minority Christian institution. Then there's another very famous institution, some of you might be familiar with, it's the Aligarh Muslim University, where a lot of students from outside of India, Bangladesh, even from Southeast Asia, go to study. It's an old university. It goes back to the 1870s, founded by one of the pioneers of Islamic reformism in India, Sir Syed Ahmed. So there's another thing to note in the constitution, which is not there in too many other constitutions, which is the directive principles. These are non-justiciable provisions which the Indians borrowed from the Irish constitution. I'm not sure how many other constitutions have it, but the Irish constitution does have it. And these are sort of exoteric kind of provisions, and they're not justiciable. And there is a long history to this in sort of in independent India in terms of the court's engagement with the question in this I can deal with later, but I don't want to go into any great detail on this. But one of the relevant provisions in the directive principles, at least for my purpose here, is Article 44, which asks or calls upon the Indian state to secure a uniform civil code for its citizens. And that has been a particularly contentious provision. And in fact, there was a heated debate. Ambedkar came down on the side of uniform civil code, saying that all citizens should, and I quote him, take full and equal benefits of all laws and proceedings, irrespective, regardless of usage, customs, race, and religion. So he was against personal laws. There were others who disagreed, and particularly Muslim members, but there were others, of non-Muslims who disagreed, and they felt that religious groups and communities should have recourse to personal laws. And this was something which actually had already been in place for almost 2 centuries. The British had actually put in place a system where Hindus had their own laws, and Muslims had their own laws, and that was again codified. They had a Sharia Act in the 1930s, whereas the Hindu law was a bit more amorphous, just as in the religion itself tends to be. Some of the anomalies that I talked about, which Donald Smith mentioned in his classic case, of course, one is what I mentioned, Article 25, which grants freedom of conscience, individual freedom of religion, but also empowers the state in many ways to intervene in religious institutions, particularly Hindu religious institutions. Again, Article 17, kind of a landmark provision in the Constitution, which abolishes untouchability, and there are other provisions in the Constitution which back up this provision. The other thing to note is the equality of citizenship is guaranteed, but then there are provisions for reservations or affirmative actions for lower castes and untouchables in elections, in education institutions, in government jobs. So that's another thing to note. So this is again the reformist element in the Indian Constitution, which is a very critical component. Again, another thing is, although no one is required to take part in religious instructions or prayer in education institutions, the state is committed to giving aid to institutions run by religious communities, and as I mentioned, universities like Al-Azhar Muslim University, St. Stephen's, Jamia Millia. There are several such institutions which do receive state funding. And till date, even though I mentioned Article 44, which calls for a uniform civil code, we still have in India personal laws in place for religious communities, most notably the Muslims, but also for Christians and Parsis, which generally relate to marriage, divorce, inheritance, things like that. I just have a few visuals because it was a bit grey. So this is just a few milestones I want to quickly run over on Indian secularism before concluding with a few court judgments that sort of bring up the tension between what the Constitution envisaged and how practically Indian secularism has spaced out. And what I'll do with these visuals is actually also bring out some of these tensions. This is a visual from this organization called the Rashtriya Swayamsevak Sangh. It's called the RSS. It's one of the components of what is known as the Saffron Brotherhood, or the Sangh Parivar, which is a group of Hindu nationalist organizations in India. And as you can see, they're kind of already dressed. They have these sort of Nehru Cup kind of thing on their head, but they had these khaki shorts. And so there was a strong sort of fascist element in the foundation of the organization. And one of the early leaders, a man known as Golwalkar, actually was openly admiring of the Nazis. So you can sort of see where they come from. And one of the sort of critical things they do is they do these mass drills to keep themselves physically active. But practically speaking, they're also they provide the cadre for the primary Hindu nationalist party in India, the Bharatiya Janata Party, or the BJP as the acronym is known. The RSS was actually briefly banned during the first few years of independent India because it was seen as having a role in the assassination of Mahatma Gandhi, 49, the man who assassinated Gandhi, a man called Nathuram Godse, who was seen to have been, or believed to have been, an RSS follower. But the ban was revoked later, and the RSS is now an organization which is legitimate, and it sort of projects itself as a cultural / religious organization which doesn't have any political ambitions. But that's again something that is debatable. But it does, for a fact, does not contest elections. It backs the other Hindu nationalist parties, but the RSS itself does not contest elections. Another landmark even in the early years is the Hindu Code Bill. So the Hindu laws were actually codified in 1954-55, and this is a cartoon by one of the more famous cartoonists of India called R.K. Lakshman, who actually used to work from the newspaper that I used to work from, Times of India, and this is sort of the tension between the traditionalists, on a bed of nails, rejecting the offer of a comfortable mattress, which Nehru was offering in the guise of a Hindu Code Bill, and there were serious disagreements and debates about the Hindu Code Bill, but that was eventually passed. But interestingly, there was no effort to codify the Islamic laws, and Nehru was famously quoted to have said at the time that the time is not ripe for me to push such things. You must remember, the partition happened just a decade earlier, tensions were still rife, and so Nehru decided that Hindu laws could be codified, but not Muslim and other minorities. Moving ahead several decades, I'm skipping some of the other important things. There was a particularly important case called the Shahbanu case, and this related to the issue of the Uniform Civil Code, which I referred to earlier. And this was an intervention by the Indian Supreme Court on a case which involved a divorce of a Muslim woman and the maintenance that she was provided by the courts. And here the Supreme Court came out in favor of maintenance for Shahbanu, contrary to the Sharia laws in place in India, and also controversially called for a uniform civil code and said that the time is now ready, that India should go ahead and there should be political consensus on a uniform civil code so as to remove these inconsistencies in Indian law. But there was actually a huge political backlash amongst the Muslims, and you must remember that the Muslim population in India is roughly 13%, which works out to well over 150 million, which makes India, I think at the moment, the country with the third largest Muslim population in the world. After Indonesia, it was for a long time the second. I think now Pakistan has gone ahead. And, so India has a very significant Muslim minority, and so there are electoral pressures. And actually the government gave in to the pressure and then enacted Muslim Women's Protection Bill, which basically nullified the coach rule. Here, 3 years later, a visual from what was a fairly significant moment in the mobilization of Hindu nationalists by a man called L.K. Advani, who later became the Deputy Prime Minister of India when the Hindu nationalist BJP assumed government in 1999. And it's interesting to note that even in the 80s, early 80s, the Hindu nationalists had really no electoral support. In the 1984 elections, they had just won 2 seats and I think roughly 7% of the vote. And by the 90s, this had jumped to well over 120 odd seats and something like 23-24% of the votes. And from then, they have sort of consistently maintained that kind of a voter share of the votes. And the BJP is really the other main national party as opposed to the Indian Congress. So they from almost very low base have reached status of a national party. 1992 again, a landmark event, demolition of a mosque in Uttar Pradesh, which was supposed to have been built on the ruins of Hindu temple. The history is of course contentious, as is with things of this sort. The mosque was destroyed, and the Hindu nationalists were of course a major player in this event happening. The issue is still under litigation, and in India, you must understand, these things take a very long time. So even though the event happened in 1992, there's litigation going on. There was a High Court ruling a couple of years ago, but the issue still remains in the courts. And finally, the Gujarat riots of 2002, some of you might have read about it, which was again in a state ruled by the BJP, by a man called Narendra Modi, which I don't want to go into the details. It was revolved around the massacre of Hindu pilgrims who were traveling through a train, and when it stopped in the station, one of the compartments was torched, and several Hindus died. There was a backlash. Riots happened. But the interesting to note was that the state government was seen to be somewhat complicit and not very active in attacking the riots that followed. Almost 1,000 people died in the couple of weeks of violence that followed, and this is a visual from the riots. And the Chief Minister Narendra Modi was re-elected. Chief Minister since then he's now the Chief Minister of Gujarat, and is also seen to be a Prime Ministerial aspirant for the BJP. India is going into elections, if it all goes according to schedule, around May of next year, and he is the BJP's Prime Minister candidate. And I really don't have too much time, so I'll just very briefly look at some of the interventions of the Indian courts vis-a-vis religion. I've written a little bit on this in my book, and there are several instances, both on things like Uniform Civil Code, on educational institutions, on use of religious propaganda in elections. But I'll just look at one thing, on how Hinduism has been defined by the courts. And this is important because India being a Hindu majority nation, and the allegations that often are leveled against India of sometimes having a majority bent. And so this one particular case that I just start off with, the case itself might seem a little arcane for many of you, but it involved a sect called Satsangis, who are the followers of Swaminarayan. In fact, the Swaminarayan sect, some of you who are from UK might have, they actually have these huge temples all over the world, and in UK they have a particularly large one. But the Swaminarayan sect argued for a separate religion status, which would have given them certain advantages under the Indian constitution. But the court rejected this content, and it drew upon all sorts of sources, including Max Muller, who was a very famous German scholar who had worked on India and on religion, and looked at other scholars from the Oxford Cambridge tradition. But what was important was that the Chief Justice then, concluded that it was impossible to define Hinduism. And so what it did was, it said that Hinduism is an amorphous entity. It does not correlate to any sort of religion or creed, but it could be broadly described as a way of life. And this way of life description has had actually important ramifications in both legal interventions as well as political mobilizations. And if you just skip a few decades later from this particular judgment, there was another set of judgments called the Hindutva rule. Now, Hindutva means Hindus, and it's sort of a core idea of the Hindu nationalists, and particularly the BJP. And this involved a case around the use of religion in elections. And I should briefly mention that besides the constitutional provisions that I mentioned, there are several provisions in the Indian Penal Code, the IPC, which prosecute people for inciting violence amongst religious communities, for using religion to inflame passions. And so this was around one of these provisions, but this was not under the Indian Penal Code, but legislation called the Indian Representation People Act, where a particular section prohibits election candidates from appealing for votes on the grounds of religion and religious symbols. And so this went up to the court. And the interesting thing here was that the Supreme Court, using that earlier judgment that I used, 6, Hinduism as a way of life, actually conflated Hinduism and Hindutva and said that both can be seen as a way of life. And this then becomes somewhat problematic, because Hindutva is a core component of the ideology of the Hindu nationalists, whereas Hinduism is, of course, the religion of roughly 80% of Indians. And to conflate both these becomes very problematic. And the court sort of remained silent on the antecedents of Hindutva, which I briefly mentioned as its own set of problems. And I would just conclude here, because I think I've gone over the half hour allotted to me. This is just an instance of how the court's intervention, and this is just one, there are several such instances in India, then becomes part of the public discourse and part of politics in India. So the conflation of Hinduism and Hindutva then gets taken up by the Hindu nationalist parties, particularly the BJP, and sees it as an endorsement of their core concept of Hindutva. And I just quote some of the ideologues who say that this is the code accepted in toto. They're one of their main ideological clients. And this has now also become part of their sort of electioneering, part of their election propaganda, and this continues to be a very live and crucial issue. And I think I just conclude here because I think I've really run out of time. Thank you.
Thank you, Dr. Sen, for very informative and also enlightening presentation on Indian secularism. The next speaker will be Professor Dr. Navid Fauzi Abifard. Please let me read his CV. Dr. Navid Fauzi Abifard is a postdoctoral research fellow at the Middle East Institute of the Nationality of Singapore. Dr. Fauzi has conducted fieldwork on ethno-religious minorities in Iran, including Zoroastrians, Kurdish, Ahlul Haq, and Baha'is. One of his projects at Middle East Institute explores the contemporary Iranian politics. He has also developed an interest in the Iranian population in Malaysia and conducted fieldwork in Kuala Lumpur. He holds a PhD and a Master of Art in Sociocultural Anthropology from Boston University and University of Wisconsin Medicine, respectively. Also MA in Applied Sociology and a BA in Interdisciplinary Studies both from University of Texas in Dallas. For Professor Abifard, the floor is yours.
Thank you very much. Let me start by thanking the organizers, in particular Professor Glazer and Professor Lee, throughout the process. They've been so attentive, answering all of my questions carefully and with lots of hospitality here. And also I have a great news, and before that let me also thank our honorable counselor from the Iranian Islamic Embassy among us, and I just received a wonderful news from a friend. It seems it's confirmed. An agreement has been signed between the Iranian nuclear negotiating team and 5+1, which is a perfect example proving the case here that elections have serious consequences, and in Iran, on the basis of the demand by the people, the current team has been able and empowered, regaining international trust and solving a major issue that hopefully will prevent disaster in the region, in the Middle East. I'm not a legal scholar, I'm an anthropologist, so I provide lots of boring, ethnographically rich text, and I read it to you. I don't have any beautiful pictures, so I have to ask you to be attentive and remain awake. Presidential elections as crisis management, administrating the challenges of representation, knowledge, and power in the Islamic Republic of Iran. Since the 2009 contested presidential re-election of Mahmoud Ahmadinejad, crises of representation, power, and knowledge destabilized the Islamic Republic of Iran's governing capacity, notwithstanding a strong Weberian state. I wouldn't get into Weberian notion of state because I believe everybody is familiar with that concept. In this paper, I argue that the following presidential elections and the victory of Hassan Rouhani 4 years later in 2013 was a confirmation and hence a way out of these challenges. Challenges of legitimacy and governing capacity that I explore here produced a fragile condition of possibility of state formation thereafter. These included ideological, political, and socio-cultural conditions that enabled or disabled efforts to govern. Crises of representation, knowledge, and power, which I explore, that the regime faced were closely linked to the challenges posed by the tightening circle of power competition, modern media technologies, and universalized ideas and ideals that conjure up tension at the local level. The contradicting and competing notions of egalitarian popular sovereignty on the one hand, and religious authority or divine sovereignty on the other in the Islamic Republic might be characterized as an aspect of the modern political form manifested in terms of ideological rift that separated we of the people from I of the supreme leader, while the latter embodies the archetype of the Shi'i Iranian. The former reflects the penetrating Western hegemonic principles. So basically, I don't want to get into the political structure of Islamic Republic, but because I believe everybody is knowledgeable about the constitution to the extent that we know that this is a very unique and complex merger between a modern notion of state, nation state on the one hand, with all the apparatuses of modern nation state, education, court, and three branches of government, merged with a Shi'i reading of the Islamic tradition, which accepts divine sovereignty exercised through a position of velayat faqih. So on the one hand, we have the modern nation state, popular, egalitarian popular sovereignty. On the other hand, we have the divine sovereignty. And the merger has embedded the constitution in this constant tension, which we'll see here how it manifests itself. So let me give a little background. In the Iranian presidential elections of 2009, the reformist camps introduced two candidates, the former Prime Minister Mir Hossein Mousavi and the former Speaker of the Parliament, Mehdi Karoubi. Due to the long-standing rivalry between the reformists and principalists, the fierce competition between the two was foreseeable. And as in the previous elections, the regime welcomed it, exploiting the legitimating power of high vote turnout rates, as we see is one of the legitimating ritual of democracy in modern notion of nation state. Speeches and interviews abounded, and for the first time live debates on the state-run TV caused a sensation night after night. Nonetheless, supporters of the candidates remained cordial and no violence was reported. However, on the night of the election, just moments before the state TV network announced Ahmadinejad the winner, Mousavi's headquarters in Baytarieh was attacked, computers were broken, and party's online TV program shut down. Almost instantaneously, images and videos showing a group of armed plainclothes police officers breaking into the building and terrorizing the staff were released and went viral on the internet. While initial demonstrations were immediate and spontaneous, candidates joined in subsequently and stood alongside the protesters. When threatened, they invoked constitutional guarantees for peaceful demonstrations, and when asked to concede, they condemned violations of people's trust and demanded the annulment of the election. After the initial few days, at the regime's behest, foreign journalists were made to leave Iran and a violent crackdown ensued. The journalist presence up to that point could be interpreted as regime's miscalculation. The authorities had prepared the ground for the journalists to broadcast a vibrant election, seeking to project to the world an image of a democratic, popular, and hence legitimate government. However, the overwhelming people outrage undermined that image and challenged the representational claim of the administration. In his first Friday prayer sermon after the election, Supreme Leader Khamenei gave tacit support to the besieged militia for the bloody crackdown of the demonstrators by warning the candidates, if you do not stop the protests, you will be responsible for the bloodshed on the streets. He also stated that everybody knows that the structure of the Islamic Republic's electoral system does not allow irregularities, let alone at the level of 11 million votes, which was the claim made. Nonetheless, the candidates and protesters insisted on their constitutionally recognized right to peaceful and civil demonstrations. Such a peaceful assertion of political demands threatened the state even more than a violent one. A violent uprising could be framed as a domestic issue that lay beyond the reach of external parties, hence legitimating the sovereign state's forceful response against the subjects who ostensibly pose a threat to national security. Whereas quashing a peaceful protest would draw worldwide sympathy for the supporters and invite criticism of the government. The anti-reformist campaign successfully stopped street protests by terrorizing the protesters. It was made public 3 years later by Ali Motahari, a principalist member of the parliament, that during the 2009, I'm quoting him, during the 2009 protests, 30 to 50 were killed. The vigilantism was either perpetrated by a shadowy, organized militant, that was the end of quote. The vigilantism was either perpetrated by a shadowy, organized militant group, which could mean that the state did not protect citizens against rogue elements, or that it was carried out by vigilantes hired by the state to achieve its goal without being accused of human rights violations. In either case, the state did not stop the killing or accepted responsibility for it, resulting in a crisis of power that cause the state to forfeit its accountability toward its citizens. At the same time, the official complaints about voting irregularities were ignored and framed as sedition instigated by foreign enemies of the revolution. Similar discursive weapons were deployed to present the regime with the excuse for further crackdown. Reformist newspapers and blogs were shut down, community centers and student organizations were dismantled and replaced by new ones under similar names by the regime. Control over the means of public discourse allowed hardliners to manage the public domain and fill the vacant discursive space with propaganda. In addition to barring reporters, within the first 3 days after the elections, broadband connectivity dropped by 54%. In contrast to the early years of the Islamic Republic during the revolutionary days, however, this control was not absolute. In fact, the modern media technology challenged the monopolies of the state over the means of communication, and the reformists were able to circulate competing narratives and images. The regime's loss of the public domain was accomplished by mass circulation of the images of Basij in plainclothes attacking peaceful protesters, assaulting old and young, male and female, and also by the images captured on mobile phones and broadcasted by all major media networks, a kind of globalized activism that some scholars use. The phrase they use to frame these kind of activities. Images managed to escape the state's scrutiny. And at the same time, the internet enabled Mousavi and Karoubi to maintain contact with their supporters by issuing letters and giving interviews. It meant that the nation was no longer the state's captive audience, and it enabled the whole world to bear witness to events within the country. Immediately after the crackdown, the regime was accused of human rights violations and pressures mounted even from within the religious and political establishments. External parties strengthened those demands, culminating in sanctions against Iranian oil, banks, and high-ranking elites. These challenges to the regime could not be tolerated anymore after Karoubi and Mousavi successfully asked people to come out in support of the Egyptian and Tunisian uprising 1 year after the officials had announced the death of the sedition or protesters. Challenging the state's representational legitimacy one more time, millions did come out, and the authorities that had equated the retreat of the terrorized protesters, now widely identified as Green Movement, with the end of demonstrations, were disoriented. At the core of the regime's failure were the state's crucial governmental functions, which was to identify key objects of regulations to regulate and produce reliable body of knowledge about them. The vast numbers of protesters who had gone into hiding meant that identifying them had become an arduous task, if not impossible, let alone producing reliable intelligence about them, resulting in a crisis of knowledge. On August 1, 2009, show trials began and were broadcasted on national TV. They were reminiscent of the Moscow trials of 1936 and 1938, when central figures of the system were accused of plotting to overthrow the regime, and senior communist leaders confessed to conspiring against Stalin, in addition to attempts to purge reformists from the political domain. The conservative-controlled regime subjected the state apparatus itself to surveillance to rid it of active reformists and their supporters. the pillars of the regime, such as the former President Mohammad Khatami and Ayatollah Hashemi Rafsanjani, who was at the time head of both the Expediency Council and the Council of the Experts, were publicly humiliated by the plainclothes militia who disrupted their speeches to sideline them. Now let's move on to 4 years later. I'm skipping the parliamentary elections, but I'll go back to it briefly later. During the recent 2013 presidential elections, the highly controlled public space unexpectedly was allowed to open up. The taboo of speaking about the former presidents Mohammad Khatami and Hashemi Rafsanjani was broken. Criticisms of the Iranian nuclear negotiating team were raised, and even freedom of Mir Hossein Mousavi and Mehdi Karoubi was demanded in public. In order to understand why such a drastic transformation of public space happened, we need to consider several issues. For one, the alarming lack of electorate participation during the preceding parliamentary elections, hence the challenge of legitimacy. So the challenge, representational crisis, the challenge of legitimacy continued after 4 years, a year before the election. Reportedly, it has been only 30% in parliamentary elections. So participation was extremely low. So needed to be recovered. But also the damaged, hence in need of repair of the supreme leader's political neutrality, the disastrous presidency of Ahmadinejad, and the threat to install his allies in the office again, the unsustainable divided public and fragmented elites, and the mounting international pressures. All of these threatened the nizam, which is a secularized term used in reference to the Islamic Republic establishment as a whole. Thus, in sum, the external unprecedented sanctions against the Iranian oil and banks and the internal challenges posed by Ahmadinejad to the religious establishment and the economy that had fractured the principalists faced the regime with an unsustainable condition in need of urgent repair. All candidates in 2013 presidential elections, Mohammad Baqir Ghalibaf, the mayor of Tehran, Mohsen Rezai, the last presidential contender and the former Revolutionary Guard commander, Ali Akbar Velayati, the foreign relation advisor to Khamenei, and even Saeed Jalili, the head of the Iranian nuclear negotiating team at the time, all similar to Hassan Rouhani, the winner of the election, criticized Ahmadinejad's administration. While deeply immersed in the Islamic Republic, a member of the Assembly of the Experts, the Expediency Council, the Supreme National Security Council, and head of the Center for Strategic Research, Rouhani, who was not a reformist, had adopted a reformist discourse. What distinguished Rouhani's campaign that could galvanize people was his political promises in a very specific way. It was only he who addressed the domestic political climate and promised a change. He challenged the official rosy image of the economy and the international politics, but more so the securitized public sphere, extremism, lack of freedom in universities and in the press, and persecutions for religious belief or political views. The other candidates, none of them mentioned these problems. Moreover, the fragmented principalists failed to reach a consensus over a candidate among themselves. As we saw earlier, due to the support the religious leader had rendered Ahmadinejad, also allowing the crackdown on protesters of the 2009 election, cost him tremendously, as it seemed he was not politically neutral. This round, on 5 separate occasions, he stressed that he had no favorite candidate, had only one vote similar to others, and when cast his vote, stated that even his family didn't know who he was voting for. This latter perhaps was a way to address accusations of his son being involved in the re-election of Ahmadinejad. He further extended the religious term of Haqqun Nas to people's vote and asked officials to protect them. This term literally means people's right, which in the Shi'i tradition is more important than obligation towards God himself. Additionally, the Revolutionary Guard were conspicuously absent from the election scene, and the Basij didn't interfere. All these indicate that there was a will not to repeat what had threatened the Nizam 4 years earlier. This does not mean, however, that the election was free and fair according to the international standards. Rather, the engineering took place in the preceding vetting processes by the Guardian Council, and even before that, the loss of the principalists and the setback to their official politics and policies were rather due to a complex combination of conditions that caught the regime off guard, a regime that didn't anticipate the rise of Hassan Rouhani. The reformists believe, and they have reasons for it, that this was not a Rouhani victory per se, rather of the people who proved that they prefer a major change. The reformists would argue that the high turnout owes much to their supporters, despite the fact that their machinery was dismantled over 8 years of Ahmadinejad and in the absence of the first or second or even third choice candidates, namely Khatami, Rafsanjani, and Aref. Rouhani didn't gain momentum until he secured the explicit backing of Rafsanjani and Khatami, the somewhat known as leaders of the reformists, during the last 3 days of the campaign, and only then he advanced in the polls. Even at this point, the hardliners were contemplating to reevaluate his qualification in the Guardian Council, a rumor that was validated when the principalist member of the parliament, Ali Motahari, warned the Guardian Council, in particular its head Ahmad Jannati, against such a post-official vetting period decision. It was too late. The dynamic complexity had already made it impossible to make changes, and it seems a decision was made at the highest level to let the combustible condition that for so long had the regime on its toes to be neutered. After his victory, Rouhani thanked Rafsanjani and Khatami by names, and newspapers became filled with their images and statements, and people were permitted to celebrate this victory on the street, many of whom wore green and hold images of their leaders. This was a remarkable transformation of the public space after 2009, when the regime had learned that any gatherings would potentially offer an occasion for protest. One of the most recent instances was during the election itself, on June 5, 2013, when the funeral procession for Ayatollah Tahiri Isfahani was transformed to a protest scene. Such instances prove that the so-called Green Movement was not over, and its social basis still could challenge the representational claim of the regime. Moreover, the poisonous atmosphere of distrust among the officials and the executive and other branches of the government had put a stall on any moves to address the international sanctions. After the disastrous first presidential debate with multiple choices and yes or no questions compared to a game show, to which all candidates protested. Starting the third debate, the condition changed. When substantive criticism of existing policies were raised, nonetheless, the officials' nervousness about the low turnout just days before the elections was more palpable than ever before. Just 2 days before the elections, on June 12, in an unprecedented statement, the Supreme Leader asked even those who might not approve of the Nizam to vote for the sake of the country. It was a rare acknowledgement of such a group of people. Eventually, participation of 72% made the reformist back Hassan Rouhani the president by almost 52% of the vote. This meant a new organizational challenge for the fractured principalists, as Rouhani won even in Qom, where Ayatollah Khani, head of the Assembly of the Experts, supported Ghalibaf. Mehdi Mesbah Yazdi, a hardliner ideologue, supported Jalili, and Muhammad Yazdi, another principalist, supported Velayati. Moreover, the principalist loss was such an abject failure of their political discourse, also their claim that reformists didn't have a popular support, that even some traditional conservatives acknowledged. For instance, Top Knock News agency close to Mohsen Rezai wrote that the loss of the principalists was necessary. They needed to learn that they win only when there is a monologue, but not when there is a debate. While the election provided a legal space to control the plainclothes police and limit the armed forces' interference in the politics as delineated by the Constitution, and to monitor the activists and gauge their real power, it also offered a protected space allowing the reformists to congregate and express their demand publicly, operating as a social valve. It also enabled the regime to partially regain the public trust and increase the turnout. At the moment, by invoking legitimacy, the main goal of the administration is to recuperate trust of the international community to solve the nuclear issue in order to remove the sanctions, which we saw today, an agreement was signed. Thank you.
Thank you, Professor Abifar, for a very informative and also enlightening presentation on Iranian politics or Iranian election. So, from the two speakers, we may learn that in dealing with state and religion, it's not that easy. There are many factors, like in the case of India, how to manage Indian secularism. It's not that easy how to manage the religious affinities, denomination. Like in one hand, Hindu as the biggest majority, and then how to manage the minority Muslim and other smaller groups is not that easy. And so we can learn from the constitutional debates in India, as well as from the court decision, and also from the constitution itself, that is always a big effort to deal with the secularism as well as with the religiosism. In case of Indonesia, my own country, Indonesia having 85 to 87% of Muslim population, and indeed we cannot call ourselves as Islamic state or Islamic country, but we try to formulate a unique formula, namely Pancasila, or 5 pillars, that all religions are similar, treated equally by the constitution. But indeed it's not that easy as well, because what law in the books and law in practices are different. So we cannot expect that people will observe, people will comply to the constitution of the laws. Because what happened in India, in Babri malls, or in Gujarat 2002 also occurred in Indonesia in different circumstances. Regarding the Iranian situation, Dr. Adifar already mentioned to all of us that the presidential election is another things in Iran. There were a conflict or a controversy between maybe the old faction or the newest faction, and there are many mullah, or including the influence from the religious group in Iran. That's make the presidential election is another things, another field of what you call it as debates, not debates in dividing the state and religion. So the struggle for hegemony actually are presented in the case of Iran and India. And without further remarks, I would like to invite question and answer for question from the floors. You have like maximum 15 minutes, maybe 3 persons. Yes, one from Indonesia. Any other participant would like to raise a question? Yes, the second, the last one. Only just 2. All right. Please mention your name and where you come from, and to whom you would like to address your question. Please.
Thank you. My name is Lailani from Indonesia. I'm from Pajajaran University. My question is for Dr. Fauzi. First, I want to comment about your paper. As we know that one of value or key element of democracy is freedom to speak, free to delivering idea and including criticism. So in your paper said that taboo of speaking about the former President Hatami and Rafsanjani was broken. I think it's in democracy it should be not big problem. It was consequence of democratic reform. And talk about consequence, if we read concept of electoral justice system, which is the concept stressing about the protection of political right on election, and one of protection method is provide a good electoral dispute resolution mechanism. And my question is about electoral dispute resolution mechanism in Iran. How Iran prepare about this mechanism, and your point of view to the mechanism should be. Thank you.
Thank you. Second.
Thank you very much to both speakers. My question is to the first speaker, though. I was really intrigued and excited by the reference to a Supreme Court case, apparently, coming to the conclusion that Hinduism couldn't properly fit any definition of religion. Now, I'm sure many religious scholars today would be excited to hear that. And yet it also must produce enormous practical difficulties. And I was just wondering whether you could say a little more about this, because if the largest religion in India doesn't technically fit the definition of religion, what does that mean for all other religions? And what does it mean for the entire legislation in that area? Thank you.
Thank you. Any other? Yes. You're the third and you're the last one before, please.
Just to add to the last question, didn't it raise any controversy as to whether the Supreme Court can decide what a religion is on a definition of a religion, any religion? It would seem to me that in many countries this would lead to a serious controversy. if any court decided that, to define the principles of a religion. So, thank you.
Here, your last one. Just mention your name and where you come from.
Myself is Dr. Mohammad Fahim. I work in Chulalongkorn University, Bangkok. My query for first speaker, I just have my observation, then afterward I will ask some queries for you. My observation is that secularism in India is symbolic and practice is different. Symbolic in terms of we have a vice president Muslim and Sikh prime minister and Dalit speaker. On the other hand, secularism is something is in danger more nowadays because it is just for the vote bank politics. Whenever election come out, so all the you called BJP use this tactic for the divide Hindu and Muslim. Recently, a lot of riots, as you mentioned that 1984 BJP was only 2 seats, but after the movement of Hindu, they are rising the seats. At the same time, now next year is election. Now a lot of riots took place in the recently 2 months back. So I just want to know, it is just for the vote bank politics only that something else? Thank you.
Thank you. So we have 4 questions, and I'm sorry I cannot undertake more questions since we run out of time. So please, Dr. Joyce, the first, followed by Dr. Abifan.
Related, since it pertains to the definition of Hinduism. The court's ruling that Hinduism represents a way of life and not a religion. It sort of grew upon some. There is a background to that. It's not that the court just came up with it. There were earlier, philosophers and thinkers who sort of put forward the idea, partly because Hinduism, unlike the other great religions, is first of all is not a text-based religion. It is no central text. Although there are some who like to argue that the Bhagavad Gita is a central text, but that's contestable. It is an amorphous entity. About that there's little doubt, because Hindus, say from where I come from, in Bengal, practices brand of Hinduism, which is very different from what might be practiced, say, in South India or say North India, because there is that sort of favorite thing. There are 330 million gods and goddesses officially, apparently, in Hinduism. So it's an entity which is difficult to define. So in that sense, I think the Supreme Court was ordering on to something which was in some ways improved. But as I was trying to say, even though it sort of seemed, if you define Hinduism as a way of life, it kind of makes it a benign, kind of inclusive sort of concept. But that paradoxically then, in a later judgment, aids the Hindu nationalists. I don't know whether it's sort of getting, I got that across correctly. Because if it becomes a way of life, then even Muslims or Christians can technically be considered as Hindus. So that's what I was trying to draw the tension between a definition which, on the face of it, many of us accept that Hinduism is a sort of different kind of religion in that sense. But that precisely can be turned around by the Hindu nationalists to further their agenda. So there is that sort of inherent tension, and you're right, it does cause sort of problems in interreligious relations as well as incipient conflicts. And to your question on whether the Supreme Court can rightly define religion, no, it did cause a lot of controversy. There were a lot of legal scholars and lawyers, even other judges, who came down heavily on this judgment, saying that it's no business of the court to define what religion is, be it Hinduism, Islam, Christianity. So there was controversy on that, but I think partly this whole train of defining what Hinduism is stems from that sort of tension again in the Constitution, where I mentioned in Article 25, where the state is empowered to intervene in economic and other affairs of religious bodies, which is seen as secular. So there is a sort of inherent tension there, even though religious bodies are free to practice religion as they wish. But because of the reformist element in the constitution, the state does get into a lot of dimension caste. But if you sort of look at, there are major temples in India which are extremely well, as are other religious organizations in India. So the state actually constitutes religious management boards to see that the accounts are maintained, the places well run. So there is that tension where the state has to define what religious practice is legitimate or pushed in a way. And that kind of, I think, gets the state into this, or the courts sometimes into these sort of conundrums where they are forced to define what's religious, what is not. And I think there is a train of argument that in the US too, there have been some famous cases where, like the famous Wisconsin, which is Yoder case, where for the Mormons, I don't know if you're familiar with that case, whether they are exempt from public schooling, where they can teach their children. So then the court, sorry, not the Mormons, sorry, the Amish, but the Mormons, it was the earlier one, whether they can have multiple wives. I'm sorry. Yeah. So there are instances where the courts are.
But the U.S. court did not define what Amish religion is.
No,
the decision there was that the parents have the right not to send their children to school.
Right. Here it was a very sort of different. But there are instances where the court, where the American courts have had to sort of define whether a Native American practice of ingesting peyote, which is a form of marijuana, whatever it is, but they see it as a religious, a religious connotation, whether that runs against the laws of, this was in Oregon. So there are instances where you have to sort of, the courts are sometimes forced to, but yeah, usually they're going to define what it is. And briefly, the last question whether secularism is symbolic and religion is, of course, there are laws against the use of religion in political campaigns, etc. And I did mention one of them, but it's common practice for it to crop up. And some of it is proscribed, some of it is not. But I would sort of disagree with you on that, the notion that if the BJP, when it campaigns or when the BJP is in power, it automatically means a shift towards a more Hindu sort of polity, precisely because the politics of India today, in many senses, militates against it, because there are no real central parties that have the numbers to form governments. The Congress has lost its dominance, the BJP doesn't have the numbers. So it's always a coalition party, and the good thing about coalitions is that they tend to moderate all the policies. So if there is a bad thing, is of course it often leads to instability, but the good thing is that it moderates hardline positions, and this was precisely what we saw in the phase between 1999 and 2004, when the BJP coalition government was in power for the first time. None of these issues really, the Babri Masjid, the Uniform Civil Code, their strident position in Kashmir, all these were put on the back burners, because if they tried to push on those, the partners would have left the coalition. So that, in some senses, the fragmentation of the Indian political situation has paradoxically, I think, helped at least in moderating it. So if the BJP was unilaterally in the majority, our things might be different. And in my opinion, in the foreseeable future, India is going to have coalition politics for a long time. So there's no single party that's going to dictate its policy.
Two questions. One of them was about the freedom of speech. Well, while I agree with you on the paper, any constitution that claims democracy explicitly put it there, freedom of speech. But you won't be able to, I think, find the country that it's absolute. In the US, you cannot burn US flag on the street. In Germany, you cannot come in Nazis. I guess here the royalty is publicly kind of sacred. But what I would say maybe distinguishes the Iranian political structure is that the whole structure is considered, is equated with a sacred nizam muqaddas Jumhuriyat Islami. So when the whole order, the holy order of the Islamic Republic, when the whole system is considered sacred, then any attack on the, corruptions, even profane material issues could be interpreted, depending who is in power, who is in charge, as an attack on the order. So, for example, during the election, it was a demand of recounting the votes. None of those Musavi or Karudi attacked the constitution, and they actually claim and still are claiming that we want this system, but we want it to honor its constitution. So there is an attempt by reformists to have the more liberal interpretation of the constitution, and maybe that would help us to shed light on the dispute resolution. There is a institution as an extension arm of the religious supreme leader. The Guardian Council has 12 members, 6 of them are directly appointed by the supreme leader from the clerical establishments, and 6 of them are constitutional lawyers that the head of the judiciary appoints them, and the head of the